All present in the courtroom, please rise. The Court of Appeals is now in session. Please be seated.
Good morning. We are here this morning with one case on our oral argument document, and I think it's yours. Taylor versus Taylor, our case number 2023-0868. And we'll go ahead and take appearances.
Caroline Olson on behalf of Jackie Taylor.
Thank you, Ms. Olson.
Kevin Call on behalf of Mark Taylor.
Thank you, Mr. Call. I think, well, I'll say it all just in case. You each get 15 minutes. It looks like you've reserved 4.
Thank you, Your Honor, yes.
And if we're asking questions as the time expires, there's no need to ask us whether to answer. We'd like to talk with you about this case until we've run out of questions. And we look forward to your arguments. If you'll restate your name as you come to the podium, just for our electronic record.
May it please the Court, Caroline Olson on behalf of Jackie Taylor. The District Court's decision to nullify the postmarital agreement contravened basic principles of Texas law concerning contract interpretation. Section 1B of the agreement evinces a meeting of the minds on all essential terms. There are 2. First, the revocation of the prenup's waiver of alimony, and second, an agreement that Jackie gets alimony on divorce calculated as a percentage of Mark's income. If there are absent terms, they are non-essential terms that simply implement and effectuate the material terms guaranteeing alimony. And as a matter of Texas law, those terms can be implied either by the parties or the court later.
Under those 2 provisions that you referenced, severable?
We think that they are, Your Honor, but we don't think that we need to get to the question of severability because we think that they are both, the contract overall is sufficiently definite on both scores that it can be enforced, both provisions can be enforced. And I think there's an important background principle of Texas law that is sort of helps set the stage here, which is, and that's the one that's articulated, I think, most clearly in the Fisher case, which is that contracts should be construed to avoid forfeiture at pretty much at all costs, and that means implying reasonable implications from fact, looking at common usage, practice, statutes to fill in any gaps. And I think that principle, not only does that carry a lot of weight in terms of interpretation, but I think it's extraordinarily telling that they have not pointed to you to a single case in Texas where a marital contract was deemed to be unenforceable for indefiniteness. They've, in fact, and out of all of the contracts and marital contracts in the United States, they've pointed to one in Georgia. We think that case is wrong and is distinguishable, but putting those concerns aside, I think it really understorms the extremity of their position here, which is that these contracts are not ordinarily invalidated for unenforceable terms. Instead, the thing that courts do is fill gaps. And I think the second threshold point that really helps elucidate how you do that in this case is illustrated by the Haynes case, which we cite in our brief, and that's a really good example. It provides a useful rule of thumb for how do you differentiate between essential and non-essential terms, particularly in the marital context. And you know, I think as a matter of Texas law, you look at contracts on a contract-by-contract basis to determine what is material. But the Haynes case, and I think other cases that are consistent with it, lay out a basic rule of thumb, which is this. Is there a division of a marital asset? A basic division of a marital asset. Those are the material terms. And what the court goes on to say is provisions that are useful for implementing or effectuating those terms, those kinds are the kinds of provisions that courts and parties can fill in after the gap. And I think actually the case is worth unpacking a little bit because it sort of shows how that works. So that was a case where the parties agreed that the husband's stock options were going to be split 40-60 between the parties, and they were only in his name. So the parties agreed on that marital division of assets, which I think is comparable to what's in Section B, A and B, Section 1B, A and B here. But what they didn't provide were procedures, for example, how should she redeem this? And how were the stocks going to be held going forward? And what was who was going to pay taxes? And what the court said, when the spouse objected to those terms being filled in later by the court as what he described material terms, the court said, no, these are implementing and effectuating terms that either the parties or the court were able to fill in afterwards because they were not the essential terms of the agreement. And I think that's exactly what you can do here and view the terms of any terms to the extent they are absent could be construed. And I think that
Well, and it's such a familiar area of the law, too. This isn't, I can envision contracts where, oh, what the heck do we do with this? But alimony is such familiar territory to figure out a date of payment. Is this going to be figured out with respect to gross income? No, probably not. We typically do net income. It seems to me like it's at least possible here that the trial judge missed the boat in that regard by not giving due regard, sorry for the redundancy, to the fact that this is such familiar territory and the missing provisions, not really rocket science to fill those in.
I think that's absolutely correct, Your Honor. And I think that it's important both to sort of recognize the difference between the commercial context, which again is like 95% of the cases that you've cited to you, where, for example, there might not be a default backdrop of what constitutes reasonable repayment terms for a unique commercial loan. That's just not the setting that we're in here. We're in a context of alimony where there are statutes, custom, and practice that we can look to fill in any gaps. And I think it's very...
I guess one of my questions is how do you choose which of those custom statutes and practices to go with? And here, I think it's significant that Article B, V, A, I guess B altogether, talks about no less than 20% and no less than 30%, which I think implies you need to figure out what the alimony would be first, and then see if we've hit the floor. And there's no indication in Section B as to just how do we look at alimony to begin with. And I've looked at the Texas family law statute, and it's a different approach than in Utah by quite a ways. And so, for example, do we follow Texas spousal support statute? Do we follow Utah alimony statute? Do we follow some other custom or practice? How would the trial judge know which of those customs, practices, and statutes to follow?
Absolutely, Your Honor. And I want to unpack that question a little bit because it gets to sort of a point that I think is part of a flaw in the way that the Mark has approached this case. Because what you've identified are terms that are present in the statute, in the contract. So it is not a question of absence or indefinite, it's a question of construal. How do we construe and implement the 20 to 30%? That's a question of ambiguity and not of absence. And how do we approach those questions? Well, we look at extrinsic evidence of intent. What did the parties intend when they used those terms?
What would, if we said there's ambiguity, what would we say, this is the ambiguous term that we're going to take extrinsic evidence on? What's the term in the...
I think the question is, what were the parties intending when they used a range or used the language a minimum of X in order to figure out how to construe those terms? And I think Jackie at least has already provided testimony on how to construe that, to which I think this court could default, or the court on remand could accept as the evidence of what the parties intended. And she said, you could do this as a gross income, annual gross income paid on a monthly basis. We already have the gross income figure, and it's just a simple calculation of 20 or 30% based on a determination as to whether infidelity existed. Now, I take your point that there could be some questions at the outer boundaries. For example, does it go above 20% or 30% against? Again, I think that's a question of construal that can be resolved if at worst at a hearing on remand. But I would say that this is not sort of we have the tools to resolve these gaps. And I think we would perfectly.
What you just said there, and I haven't read all of Jackie's testimony, but even the way you just framed it, it doesn't sound like she testified, we intended for it to be gross income, and we intended this or that, but that, you could do it this way. And that's a little different to say, here's how you could do it versus here's what my intent was when I signed the contract.
I think it's actually, for what it's worth, Your Honor, I actually think it's closer to the latter. I would direct this court to her testimony at Record 2835 to 36, where I think she was pretty clear that what she anticipated was a 20 to 30% of gross income. This was her understanding of the contract, that would be reduced to an actual dollar amount, very similar to the way that child support is paid. So it would be paid monthly like child support. It would be an average number. So basically she said she assumed it would be an average number calculated probably at the time, around the time of divorce, so she wouldn't have to keep going back to court every month to ask for things. So I think that's how she testified that she anticipated, not just that that's how she sort of understood the contract could work. But again, we have some background principles that could help resolve here, I would say, as a matter of Texas law. And I would refer the court to section 7.006 C, which talks about what is a court to do when it has a marital agreement, and it's allowed to review. What Texas courts do, at least, is they look and they make a determination: is this just and fair? And if the court says that it's not that the contract is not enforced; it's that the court sends it back to the parties to flesh out the agreement even further, or it holds a contested hearing. But it's not, the outcome is not, this contract is not enforced. And if you look, it's because as 7.006 talks about, Texas has a strong public policy in favor of parties being able to resolve these kinds of disputes voluntarily and out of court.
But to Judge Luthie's point, I think there's a little daylight between what we intended, which is typically the exercise in fleshing out ambiguous terms. What we intended was A, B, and C versus what I anticipated was A, B, and C.
That's correct, Your Honor. And if what the ultimate conclusion is that, her testimony as it exists now is insufficient to fill that gap, then again, that's something that could be fleshed out at a hearing. We think that given the way this was all teed up below, you can default to the testimony, because I think that they've essentially waived their right to provide a testimony on the interpretation of the contract, given the way this all went down. But the worst case for us is that we just go back down to have another hearing on what the parties intended. It's not that the contract is not enforced; it is not enforceable. And I would just say too, I think, to the worst case scenario for us, I think we would be fine stipulating to a 20 or 30% number without having to figure out that flexibility at the back end. But I think it is even the respondents' petitions.
Can I ask a question there, though? You may be willing to stipulate to that, but as a matter of law and contract interpretation, doesn't the trial judge need to initially walk through some rubric and figure out what alimony would be, and then figure out if it meets the 20 or 30% floor?
Sure, and one way.
And so if the court does need to do that, Utah law and Texas law are quite different. For example, in Utah, when figuring out alimony, courts look to what the marital standard of living was. In Texas, it appears that for spousal support, you look to what's the minimum reasonable need, which could be quite different. And there are other factors that are quite different depending on where you go to look for it. This kind of comes back to an earlier question, but how do we know which set of general alimony rules the court should apply to reach that initial number?
Yeah, so I think a couple of things. So the contract says that it needs to be construed according to Texas law. So I think you would look to Texas law first. And I think while we can use Chapter 8 of the Texas Family Code to fill gaps, I would just be clear that I don't think that is actually the outer limit of what the parties can do. And I think Texas law is very clear on that. The parties are free to contract for alimony in a voluntary agreement without respect to what the spousal maintenance requirements are. I think that's just evidence of custom and what we could use to fill gaps for implementing terms.
Point to the term in the contract, Texas law applies. We look to Texas law, but overlay it with the post-nup, and if there are things in the post-nup that contravene the ordinary approach under Section or Title 8 in Texas, follow the post-nup, otherwise use Texas law to fill in the gaps.
To fill in the gaps, and then also, as I mentioned, there's 7.006C, which says that to the extent that what you get after that is something that the court doesn't think is just and fair, then the option for the court then is to give it back to the parties to try to negotiate further or to have a contested hearing. But again, we have the tools in statutes to fill this in. So I don't think there's a guessing game. There's tools that we don't necessarily know what the final outcome would be, but that's not the question. The question is there an agreement as to the essential terms? And that we absolutely have that agreement in the meeting of the minds.
So is that tell me if I'm characterizing this correctly, that instead of looking at this agreement, this contract between these two people, more from a general perspective, right? What does this agreement entail? It entails that we agreed to waive alimony. Now we're going back on that. We're agreeing alimony can be paid. First and foremost of all. Second, here's sort of a general idea about our agreement. No less than 20% or 30% if there's infidelity, that's it. Did the court get a little bit too into the weeds of what the actual amount of alimony should be? And why is the actual amount of alimony not required to be part of this agreement?
Sure, yeah, I think that's right. And I think that the approach was a little bit nitpicky in terms of what terms need to be there and what terms don't need to be there. If you look at the context of the agreement overall, which is where Texas courts say that you need to start, the point was to agree to a waiver to revoke the waiver of alimony and to ensure a minimum payment amount of alimony and not necessarily to specify. And I don't think, again, the analogy to commercial context is not a perfect one. So I want to resist importing all of the notions from commercial contracts where there aren't a lot of equitable and statutory backfills. But one thing that we do know from commercial law is that there are lots of different ways that we can come to an agreement that is definite. For example, a cost plus contract or a formula. These are all things that this court has said and Texas courts have said. The fact that there isn't, it's not the number, the contract price isn't reduced to a specific number is not something that makes it indefinite. It just means that you follow the formula. And I think that that's what they did here. And I don't think that that's that different from saying, for example, in the Haynes case, we're dividing stocks 40-60. And by the way, the number of stock that you're going to get might vary because the stock might split or some other thing might happen that changes the exact amount that you get. But we have the formula to figure this out. And we have the tools to backfill any potential, absent terms. And I would just get to that point that
But do we have that formula? I mean, the agreement is no less than. That they didn't, at least in this document, this agreement, they didn't agree to what it would be. How is that insufficient, or not? How is that sufficient that it's not an agreement to agree to something else?
2 points, Your Honor. First is that I think that the cases that they've cited make it pretty clear that in Texas, when you have an agreement to agree, usually there's something in the face of the document that suggests that it's an agreement to agree as opposed to, for example, a notarized document that suggests that we're leaving future terms open to further discussion. And that's not what we have here. And I think to the extent that there's, again, it's sort of getting to is it an indefinite term or an ambiguous term? Because to the extent we don't know what the outer parameters are of 20 to, at no less than 20 to 30%, then that's something that can be resolved through extrinsic evidence as opposed to voiding the contract itself. That's a question of interpretation, not one of absence. And again, if we get back to the district court, I think that we would be willing to stipulate to a 20% or 30% at the start game to just resolve any ambiguity in that front. And then we can just go from there.
It seems to me that at least how you measure income is not an immaterial term, because the swing could be so vast depending on how you measure. Even gross versus net, that alone can be quite a swing. Plus, what do you include in that number? But income is a term that is right in the contract. Are you suggesting that income is ambiguous?
From context, Your Honor, we don't think that it's ambiguous. We think if you look at the overall context of context, custom, and practice, it is very reasonable to conclude that that meant gross income. And again, it's an ambiguity.
I wonder how you get to there, given Judge Orm's statement earlier that typically we use net income. And now you're saying, no, I think it's quite clear we use gross. How do we bridge this gap and say, nope, this contract meant gross as opposed to net?
Well, Your Honor, I think because the parties were contracting in Texas, where the default is we're under Chapter 8, parties use gross income, that was the default custom in which they were contracting against. I think that's a difference between Utah and Texas law, but because their context and custom was Texas, they could use that. But, I just want to make a point and get 2 points, which is one, to the extent that there's any concern about, is it gross income or net income, that's an ambiguity that the parties can resolve through extrinsic evidence as opposed to an absence. But I would just say that, again, underscoring the extremity of their position, I think their view is this contract could not be enforced even if you gave Mark the benefit of the most generous interpretation of the agreement, which is that 20% of net income at a payment schedule that is favorable of his choice. I think he would say that this contract is still not enforceable. And that's just not what the parties, that's just not how we interpret contracts. I mean, his view is there are a couple of terms here that I don't know. And so even though I agree to revoke the waiver of alimony, and even though I said in this contract 20 to 30%, and it was notarized, and I signed it, and I said I did it voluntarily, she gets nothing.
I have an ancillary question before we're done, unless others. I think there are only two decisions that the district court made, but it sounds like you're asking us to make some additional decisions, like that Mark waived the opportunity to put on additional evidence of intent if there is an ambiguous term. The district court didn't make a decision about waiver or a number of other things. Why should we be making decisions that the district court didn't already make?
Your Honor, I think it would simplify things, and there are questions of law that I think this court can make and provide. I think this court regularly provides guidance for how to help simplify how proceedings will proceed on remand, and I think this court could certainly simplify things for the parties by providing guidance on, for example, the fact that we're going to interpret the contract as gross income. We can use Mark's the gross income number that the parties agreed to for purposes of child support.
But are you asking us to make decisions about what infidelity means or intimate contact means under this contract or things like that? You're not asking us to reach that far down the process and make those decisions?
No, Your Honor, I don't think so. But I think that the court certainly could provide guidance, within the court's discretion to simplify the proceedings on remand to make. And I think we think the ingredients are there for this to be a very relatively simple calculation on remand, and that this court could even expedite that process. But again, the court below reached the decisions that it did as to the unenforceability, and at a minimum, we think those should be reversed.
Thank you.
Thank you, Your Honor.
Mr. Call.
Morning, Your Honors. May it please the court. My name is Kevin Call. I represent Mark Taylor, the appellee. We agree that this appeal involves a straightforward application of contract law, not family law, and that the only issue is whether Judge Mrazek erred in ruling that the spousal support / alimony provision of the postmarital property agreement is unenforceable. In a contract like this one, which is really just a contract for the payment of money from one party to another, the amount of the payment and the terms of payment are inescapably essential terms. The parties don't know what they agreed to. Jackie doesn't know what she agreed to. Judge Mrazek could not determine by reading the plain language of this contract what the parties agreed to.
That's true with respect to the second of the two issues that Ms. Olson identified. But if those two provisions are severable, yeah, you're right. Too vague, the provision about how to set alimony, but the other, arguably self-standing provision that the prenup waiver of alimony falls by the wayside, why wouldn't that suggest the propriety of remanding for the court to calculate alimony in the usual way?
So Judge Moratzik correctly applied the law of the state of Texas, and I think the same in the state of Utah, regarding severability. A contract provision is only severable once found to be unenforceable if the unenforceable provision was not a main purpose of the agreement. And Judge Moratzik found that the calculation of alimony that the parties had putatively agreed to was the main purpose of the agreement. And so there cannot be a severance or severability in that severableness in that case.
As a practical matter, would that really matter to your client? Because where under the contract Texas law is the default, and it doesn't seem that this is a case where Texas law would allow alimony in any event.
Right, well, that's, not only was the second part that was unenforceable the main purpose, but the prior clause that that Jackie now seeks to sever or enforce was mutually dependent on that promise, because she argues that, and Judge Moratzik said that Mark wouldn't have agreed to just eliminate alimony unless he knew what the calculation was going to be, and that's fair enough. But I think Jackie would not have agreed to eliminate the waiver of alimony if not for the supposed calculation that she had inserted it about the 20 or 30%, because as noted, there was a premarital agreement. She sought the premarital agreement. She had wealth and resources, and she may have been held to pay alimony conceivably if we were just applying the substantive family law of a foreign jurisdiction. She might have been held to pay alimony, and that was not her intent. And I think that's clear just from the face of the agreement, that the parties didn't intend to invoke all of the substantive family law regarding spousal support of whatever jurisdiction they found themselves in, and she might pay him or he might pay her. But then they put in this provision for a 20 or 30% that he definitely pays her based on infidelity. The intent of the parties based on the four corners of the agreement don't support that. So I think Judge Moratzik correctly ruled the severability was not appropriate in this case.
So, I was just gonna say, so really, bottom line, it's not necessarily the agreement to revoke the waiver of alimony. I mean, that's the point of this. But really the point for Jackie was actually to get alimony. And because there's not sufficient terms outlined in the agreement, none of it matters.
Precisely. In fact, Jackie says repeatedly in her brief that there are only two essential terms. One, that we eliminate the waiver of alimony, and two, that I get alimony. And that's not, that doesn't follow from the analysis of and the application of the law.
And is that primarily because because of the way that Texas is, that, alimony is not a thing but what about the provision that if the jurisdiction does not provide for spousal support, this payment shall be characterized as a division of marital property? That doesn't matter?
No, I don't think that the provision that says that if a jurisdiction doesn't acknowledge alimony, that this will be characterized as a division of marital property. I think that Jackie and her counsel in Texas were envisioning that she wanted to get alimony from Mark, and she wanted it to be 20 or 30% of his income, and she didn't want a jurisdiction's non-recognition of alimony as a statutory concept to interfere with her ability to assert that she's entitled to that payment from Mark. But that doesn't really affect the fact that there's not essential terms to enforce a payment from Mark to Jackie, and there's not a severability option here for eliminating the waiver of alimony. Certainly, if we only eliminated the waiver of alimony, we severed that. If they were in a jurisdiction that didn't recognize alimony, she wouldn't be entitled to anything. And I think the court's correctly pointed out that she wouldn't receive alimony in Texas. It's not called alimony. It's not even called spousal support, which is the other term used in the postmarital agreement. It's called spousal maintenance, and it's only available in very limited circumstances, which Jackie didn't qualify for and wouldn't have qualified for. She should have known that she wouldn't qualify for it when she filed the petition for divorce less than 10 years into the party's marriage. So it just wasn't it wasn't the intent of the parties to incorporate the substantive alimony laws of some foreign jurisdiction when they did this. And I think that would be an essential term. If the parties were saying, I think that there was some discussion about, well, first the court determines what alimony it might order anyway, and then it tests that against his income to see whether or not it's 20 or 30%. But that we're going to invoke the alimony statutes of a jurisdiction, and that our alimony analysis is going to be based on need and ability or financial resources of the parties or the minimum reasonable needs of Jackie. There's no formula, there's no method or procedure, there's no analysis that the contract directs the court to take to enforce the agreement.
Could we say it this way? And I want to quote some of the key phrases from Texas law that I think are important as a backdrop to this question. We may look to the relationship between the parties and the circumstances surrounding the contract to determine if the terms were sufficiently definite. Texas courts will not construe a contract to result in a forfeiture unless it cannot be construed in any other way. The law favors finding agreements sufficiently definite for enforcement, particularly where one of the parties has performed his part of the contract. I think that backdrop has to inform us that there were threats of divorce, there were allegations of infidelity, and I know those haven't been proven, but there were allegations as part of the backdrop. And rather than divorce and go forward amidst the allegations of infidelity, Jackie stays in the marriage, which could be viewed maybe kind of like partial performance, and even moves from one state to another. Against that backdrop, we have an agreement that says before we weren't going to do alimony or spousal support, or the prenup uses a number of terms to try to capture everything. We're going to do away with that waiver, and Texas law is going to apply. Why can we not then just look to the Texas Family Code for the tools as our tool bag for any absent terms? And that tool bag allows a trial judge in Texas a lot of leeway in figuring out payment frequency, what the number should be, and in terms of setting a cap in Texas, even says here's how you calculate income. Why can we not take that route?
Regarding the context and the circumstances, the facts of the case, as you cited, Judge Mrazek never made any findings of fact in this case. He correctly ruled as a matter of law based on the four corners of the agreement and the intent of the parties as manifest in the language of the agreement, whether there were essential terms that he could determine what the agreement was, what the obligation was, and how a remedy how the court should provide a remedy, if it should provide a remedy at all.
On that point, is your client contesting that there were threats of divorce?
Is he contesting that there were threats of divorce? I guess I'm not thinking of the specific testimony from Jackie that might have established that if Judge Mrazek had made findings of fact on that. He didn't make findings of fact on that, and I think that Mark had a very different, as in my brief I kind of laid out in the introductory section, that he has a very different view of the parties' marriage and how things unfolded and how the negotiations went, that not just that there were threats of divorce, but there were threats that I'm going to take the children and the animals and I'm going to go to Florida and you'll never see them again. And
It does
she would
sound
dispute
like,
that.
it does sound like though that both parties agree the relationship was on the rocks and that the post-nup was put in place so that we keep trying.
Putatively, although Jackie, you mentioned that may have been some kind of consideration if Jackie stayed married to Mark. She really didn't. She filed for divorce within a year of signing the post-marital
And
agreement.
allegedly he was engaging in infidelity
Yes,
within
and
a
he
year.
would dispute that if we got into a fact-finding context. And he was prepared to dispute that. But I think Judge Mrazek correctly ruled that, look, I don't need all of these facts. I don't need to make determinations about credibility and the circumstances. And
So if we then go to the next part of my question is why can't we just turn to Texas family law statutes for our tool bag to fill in whatever gaps there are?
Because these are essential terms, and those are distinct from non-essential terms that aren't fundamental to the parties' agreement. In an agreement for the payment of money from one party to another, I'm going to pay, there's going to be an obligation to pay her spousal support / alimony until she remarries or dies, the amount, how it's calculated, how often it can be adjusted, if it can be adjusted at all. Those are
Well,
all
tax-
essential terms.
But there is an express reference in the post-nup that Texas law applies, and Texas law says when you can adjust alimony, when there's been a substantial material change in circumstances. We could plug that in. We can plug in an income term from Texas statute. Why can that is an express reference to Texas law. It contains a bag of tools. Why can't we use them?
I think that the principle from Texas law that we've cited in our brief is that the court, if the contract is missing essential terms, the court cannot add, alter, or eliminate essential terms in order to supply them. And I think you're also kind of getting into the argument that Jackie makes that there is a mere ambiguity in the terms in this case, and that the court can look to extrinsic or parole evidence, other sources, customs, context, in order to resolve the ambiguity. And there's Texas law on this point, and it's consistent with what Jackie cites in her brief, that ambiguity arises in a contract interpretation context. And here we're dealing with a contract formation issue. Judge Moravcsik, we think, correctly found there was a failure of contract formation. There was never a clear offer that was sufficiently clear that it could have been accepted by market. There could have been a meeting of the minds. So resolving ambiguous terms
Well,
that
why
appear in the contract.
why can't we just say the income term is ambiguous and send it back for evidence on what was intended, gross versus net, what streams of money were intended to be part of income?
The term income can certainly be ambiguous in some contexts, but in this case, I think it's important to note that in asserting that there's merely an ambiguity, Jackie doesn't establish that there's an ambiguity. Ambiguity means that a term is susceptible to two or more reasonable interpretations. And I think that a party asserting there's an ambiguity needs to come to the court and explain what the two or more reasonable interpretations are.
Sorry to interrupt you, but doesn't the party need to just come with one reasonable interpretation, that this is the one that I meant? And then we see if the other party came with a different reasonable interpretation.
Actually not. So I would cite the case of Maxey v. Maxey, which is a Texas Court of Appeal case from 2020, found at 617 Southwest 3rd, 207. The court in this case observed that contract language is not ambiguous simply because it is unclear or because the parties assert forceful and diametrically opposing interpretations. If the contract contains two or more reasonable interpretations, the contract is ambiguous and a fact issue exists regarding the party's intent. And another Texas case, the American Manufacturers Mutual Insurance Company versus Schaefer, a Texas Supreme Court case from 2003, found at 124 Southwest 3rd, 154. An ambiguity does not arise simply because the parties offer conflicting interpretations. An ambiguity exists only if the contract language is susceptible to two or more reasonable interpretations. We have not heard two or more reasonable interpretations of the contract. We've been told that it's either net or gross to kind of give the impression that there's a dichotomy between net and gross, but even net income is an ambiguous term. Even gross income would then be itself an ambiguous term. What are we including in gross income? Are we allowing for business expenses or tax deductions? Or is it simply all of your receipts from all sources before any deductions? So I don't think that we've really been presented with an ambiguity here. And the mere presence of an ambiguity doesn't render an unenforceable contract enforceable because it's ambiguous. I think you would have to show that it's clear and definite, and the parties had an intent to be bound and knew the obligations they were undertaking, and yet there is a term that's ambiguous, and we need to hear extrinsic or parole evidence of the parties' understanding of that when they sign the agreement.
Your bottom line there is that these were not ambiguous terms, these were indefinite terms.
Right. Does the court have any questions for me?
I think we're good.
Thank you.
Thank you for your argument. Ms. Olson.
3 points, Your Honor, and I want to start with severability here. I think the question is, can a contract have multiple purposes, and can any of those purposes still be fulfilled, i.e. would they still have entered the bargain even if the severed term is gone? That's in the In Re Poly America case that we signed. And I think that that's true. Even without the provision guaranteeing a minimum amount of alimony, it is very clear from the contract that the parties were also separately negotiating for a revocation. And it's interesting, if you look at the text, which is at 1807, it talks about the two different things differently. So the text says, we agree to amend the provision of the prenup, and we agree to eliminate the waiver of alimony. And then it goes back to using amend to refer to what BB and BA are doing. And so it's clearly distinguishing between those two things.
Here's the danger I think that you run with that argument, and then you tell me I'm wrong. That if we say, we don't know about this minimum part, but at least we know they waived, or they did away with the waiver. We now look at Texas law. And if we were to give guidance on remand, as you're suggesting, as I look at Texas law, Jackie's ineligible for alimony under any circumstance.
I think that's a great question, Your Honor, and I want to push back with it on it because I actually don't think that the question that if you just enforce the revocation of the waiver of alimony, that Texas law applies. Texas law governs the interpretation of the contract. What the revocation of the waiver of alimony does is put you back to square one. So the agreement clearly contemplated that the parties were going to be separated, potentially separated in a different jurisdiction.
Before you go, well, if you're saying, once we take away the waiver, the reference to Texas law no longer matters, then that undercuts us saying, well, we've got this nice tool bag of Texas law. You're saying, no, you don't. You're back to just looking at the whole universe of how do we figure out this contract. It seems like you can't say, we want you to look at Texas law to fill in terms if it isn't severable, but if it is severable, you can't look at Texas law anymore. Help me understand
Let me try to
that.
break it down, because we think that the tool bag of Texas law applies if there's a provision of the contract is missing. The only provisions of the contract that they've said that are missing are in the provisions that deal with the minimum alimony amounts. So you can apply Texas law to fill in those gaps. Let's assume now that that provision goes away. We're still construing the contract in light of Texas law, and there's nothing in Texas law that says that the parties cannot revoke a waiver of alimony. And all that does is get rid of the prenup's waiver of alimony. So what do you do to calculate it? There's nothing in that world that says, well, you look at alimony based on Texas, you're just back to a world in which the parties, sort of a square one, where the parties had never talked about alimony at all. That's the end result of the contract. And then it's not a question of filling in terms, it's just a question of looking at, we are in a jurisdiction where a divorce decree is going to be entered. In that world, is a party entitled to alimony? And in that instance, because the divorce decree is being entered in Utah, I think it is perfectly reasonable to look to Utah law to determine whether Jackie is entitled to alimony. And I would just, though, say that even if this court disagrees and said, actually, we think that it would be fair to look at Texas law for alimony, there hasn't been a factual determination that Jackie is not eligible under the spousal maintenance statute. I think that would, at minimum, need to go back for a remand for factual determinations, but the court never got to that step. And so I think that that's something that would be important to go back to on remand. I don't think that we can, the trial counsel or counsel's assertions aside, there are no factual findings on that point, and it's not dispositively demonstrated that she would not qualify. The final point I want to make is this assertion, which is that all of the missing terms are essential, and I have not understood them to provide an explanation as to why it was essential to Mark to know the documents that would be needed to use to prove income, or why it was essential to him that he needed to know whether he's going to be paying on a monthly or bi-monthly basis. There just is no explanation for that, and that gets to the sort of more fundamental point that I made in the opening of Haynes, which is those are effectuating and implementing terms that Texas law does not generally regard as material terms. All of the, he came in and said, this is a contract about the payment of money, and the money is a material term. And even in the commercial context, that's not the law, because there are plenty of contracts in the commercial context where courts have supplied reasonable price terms. And again, as Judge Orm made in my opening presentation, this is a very different context where they have not pointed to a single case in Texas that has been deemed unenforceable as a matter because of indefiniteness. And again, I think he keeps saying, well, because it's too indefinite, I don't think that it would be fair. And I would just point this court to end with record citation at 1319, and this is Mark in his own sworn deposition testimony. I never once said I don't want to pay her alimony. I'm not that kind of a person. Alimony for life? Sure, but not alimony. I don't mind paying alimony at all. So I don't think that there can be any real question that there was an intent by the parties for her to pay some amount of money, and to the extent there's questions about what that amount is, those are questions that, Judge Luthi, as you said, the court below has the toolbox to fill in to the extent there are questions, but I don't think there's any question that there was a meeting of the minds that Mark would be paying some alimony.
Thank you. We appreciate both of you. The briefing was very good in this case, and we appreciate your oral arguments today. We'll take the matter under advisement and get you a written decision as soon as we can, and we'll be in recess.